for this audition. And that audition was at Warner Brothers. It was whatever film it was.
And when were you performing at the Rock in Rio?
Oh, sorry. Yeah, that was I believe it was the 24th of September.
In what year?
That was 15.
Right away, notice what's happening here. The attorney is building a timeline, linking Amber Heard's career opportunities with key moments in her relationship and professional life. It may sound routine, but in court, establishing a clear chronology can become incredibly important later when credibility is on the line.
What do you understand happened after Ms. Heard auditioned for Aquaman?
After Ms. Heard's audition, or possibly auditions, for Warner Brothers and I suppose the creative team, Ms. Heard had expressed to me that the film was going to be, Warner Brothers had said that the film was going to be shooting in Australia. And Australia was for Ms. Heard, that was a particular...
And there's our first courtroom speed bump. Whenever attorneys approach the bench or objections start brewing, it usually means the testimony is drifting into territory that could violate evidence rules. The jury doesn't hear those side discussions, but moments like these can completely change how a witness is allowed to answer.
Potential problem, which...
Objection, Your Honor. Your approach?
Okay.
I apologize, Mr. Depp. Could you please continue? What happened after Ms. Heard auditioned for Aquaman?
I was informed by Ms. Heard that the film was going to be shooting in Australia, and that was of concern to her, and because it was of concern to Warner Brothers. So she asked if I would, because I'd had a multi, for a few years I'd had a multi-film deal with Warner Brothers, and so we'd been in business together, so I knew these people. I'd been on films with them, so she asked me if I would speak to them. I made a phone call.
This is a classic hearsay battle. The witness is about to tell the court what someone else said, and opposing counsel immediately jumps in. Hearsay rules exist because courts generally prefer testimony from the original source rather than second-hand accounts. Watch how quickly the lawyers react. Every word matters.
And I spoke to...
Objection, hearsay, Your Honor.
I don't believe he said anything. I think he was going to say who he spoke to.
All right, we'll see. Overruled at this point.
I spoke to the three upper echelon Warner executives: Kevin Tsujihara, Sue Kroll, and Greg Silverstein.
Notice the pattern. The moment Depp starts moving from who he spoke to into what was actually said, the objection lands. That's a subtle but important distinction in trial law. A witness can often explain actions they took, but repeating specific out-of-court statements is where attorneys start reaching for objections.
And I told them that...
Objection, Your Honor. Hearsay.
All right, I'll sustain the objection. Next question.
What was the result of you speaking with those individuals?
Well, I can only say that ultimately she did get the job in the film. So
this testimony is designed to leave the jury with a simple takeaway. Depp is suggesting he used his industry connections to help Heard secure a major career opportunity. Whether jurors view that as supportive behavior or simply background information is up to them, but you can see why this line of questioning matters.
Well, hopefully, I suppose I had curbed their worries to some degree.
Mr. Depp,
And now we shift gears dramatically. Up until this point, the focus has been on career opportunities and professional relationships. But the questioning is about to move into allegations of drug use in Australia, one of the most heavily disputed parts of the entire case. Pay close attention here, because credibility becomes the central issue.
do you recall Ms. Heard testifying that she saw you consume 8 to 10 MDMA pills while you were in Australia in March of 2015?
Yes, I do remember that.
How
I
many?
also remember her saying that I took a handful.
Objection beyond the scope. Question.
Sorry, that was